this is Paul Hitchcock with the Estate and Asset Protection Planning firm BarthCalderon. Thanks for joining today. We have a really great presentation. We have two speakers. The first is Steve Williams from the law firm Fried & Williams. They represent landlords of rental income properties and tenant disputes and other issues. And Steve's going to walk through some really great information about what he's seeing today with tenant disputes, issues that can lead to lawsuits, how to protect yourself. That'll be great. The second presenter is our founder here at BarthCalderon, Harry Barth. He will be talking about asset protection planning. So if you do get sued, whether it's a tenant issue or something that happens away from the property, Harry's going to touch on both, how to protect your assets from that lawsuit. And if you've listened to any of our webcasts before, you'll know that we put on about 50 workshops a year all across the country to many incredible organizations, including the California Apartment Association, the San Francisco Apartment Association, the Beverly Hills Realtor Association, and just a ton of others. And so we do a lot of work and help property owners, business owners, families across the country. So we're really in tune to the issues that impact you. And this webcast is going to address them and help you to understand how to protect yourself. So Steve Williams is going to start out. Thanks so much for listening. And I'll say before we jump in that if you ever have any questions on any of the issues in these webcasts, we've got a great free assessment we do that'll take a look at your current planning and give you some expert input on holes in your planning or opportunities to improve it. So thanks again. And now here's Steve Williams.
Welcome, everyone, and thank you for tuning in. I am going to talk today about some issues for property owners and landlords when it comes to potential lawsuits by tenants. And I'm going to focus more on some of the significant types of lawsuits. Now, there are really, we're in California, we're in the United States, where anyone can really sue anyone for just about anything. And that's true in the landlord-tenant world as well. So there's a multitude of different types of lawsuits that a landlord or a property owner can face. But again, I'm just going to focus on a couple that I have seen are more common and some serious ones, a little more serious and more common in my practice in representing property owners. And just to start, the most common basic claim that I see of lawsuits in the landlord-tenant world are small claims court disputes. It's usually disputes over security deposits. Again, I'm not going to focus on those types of things, but instead, I'm going to focus on a couple more severe ones like wrongful eviction lawsuits and breach of the warranty of habitability lawsuits, which are becoming more and more prevalent. And within the realm of breach of the warranty of habitability are lawsuits like exposure to mold and some of the more toxic substances. So I'm going to focus on those today and really just sort of outline those types of tenant claims and lawsuits and things that you may be able to do to defend or help prevent those types of things. And why are these types of lawsuits so prevalent? And well, again, the courts in California and the United States make it very easy for people to sue and avail themselves of the court process. And they can be very profitable for tenants, or more specifically, profitable for tenants' attorneys. Now, there are other types of claims that can be litigated in areas like rent controls, jurisdictions before rent boards. But again, today I'm focusing on lawsuits in courts. So the first I'm going to talk about is the wrongful eviction lawsuit. And the first is, well, are you complying with eviction laws, or have you run afoul of some eviction laws? Now, these laws can be pretty complicated in certain jurisdictions. Now, in the Bay Area, for instance, San Francisco, Oakland, and Berkeley all have very prevalent and strict eviction control laws, which means that a property owner or landlord has to have just cause in order to evict a tenant. And they're very narrow grounds to evict. Southern California, the same thing. There's some jurisdictions down there as well, including Santa Monica and Los Angeles have some form of rent or eviction control. And really, these laws are expanding. Just over the last couple years, over a half dozen cities throughout California have proposed or even passed additional or some form of rent or eviction control. And I just learned last week that even in California, the state legislatures is looking to, some tenant advocates are looking to propose some legislations to invoke some form of eviction control statewide. So while you may be sitting in an area where there is no form of eviction control or rent control, that may change. So it's important or significant to know the laws of the state as well as the local jurisdictions, and that you comply with those laws. So typically, in order to terminate a tenancy, you have to have either just cause at the local level if it's required, or at the state level. Really, you can evict a tenant for any reason or no reason at all, unless there's a local law that restricts that. You just can't usually discriminate or retaliate. So otherwise, you could evict for any other reason. Now, in order to evict a tenant, you have to, or terminate a tenancy, you have to give written notice. It's never sufficient that you give an oral termination of tenancy. Even an email notice of termination may be improper in accordance with local and state laws. So typically, you have to give some form of a termination notice. The most common notices are, one, a 3-day notice to pay rent or quit. That's one of the more common bases for an eviction in California. The 3-day perform or quit notice, so you have the 3-day pay rent or quit. 3-day perform or quit is to terminate for a violation of some other obligation of the tenancy besides rent. So the tenant breaches some other provision of the lease. The other is the 3-day notice to quit. If the conduct is risen to the level that it's sufficient to not give the tenant an opportunity to cure, then a 3-day quit notice can be given. That's an example, or an example would be like a nuisance or an illegal use of the property. Those could warrant a 3-day quit notice. And then the third, or the fourth, excuse me, is the typical 30 or 60-day termination notice of a month-to-month tenancy. And whether it's a 30-day or 60-day is dictated by the length of the tenancy. So if the tenancy is in excess of 1 year, then the landlord is required to give a 60-day termination notice. So once you have properly terminated the tenancy, then you can't just change the locks. It's called self-help. You can't go and change the locks or put the tenant's personal belongings out on the street and basically lock the tenant out. You have to avail yourself of the court process, and it's called an unlawful detainer action in court. So you avail yourself of the court process in order to basically evict the tenant and remove the tenant from possession. So just because the notice is expired and the tenancy is officially terminated, if the tenant is still in possession, they're in unlawful possession, but you can't just change the locks on your own or kick the tenant out. If you do, you really do subject yourself to potential liability and potential tenant claims. So you have to go through the unlawful detainer process. And really, an unlawful detainer lawsuit is one that is in the court system for really possession of the premises. It usually takes a few months to run its course. And what you're seeking is a judgment for possession of the unit. And then once you get that document, you take it to the sheriff in the county where the property is located. And the sheriff actually goes in and physically removes the tenant if necessary and restores possession of the unit to the landlord or the owner. So that is, in a nutshell, a proper basis or proper way to terminate the tenancy. And through each of those steps, you have to make sure that you're complying with all applicable laws, whether that's state or local laws. Now, wrongful eviction lawsuit. So what is that? Well, it's a lawsuit filed by a tenant alleging that a landlord or an owner has improperly displaced the tenant. And I've seen some variations of that, including attempted wrongful eviction, where maybe the tenant's still in possession and is still trying to invoke a wrongful or an attempted wrongful eviction claim. But generally, it's the improper displacement of a tenant. And that can be through negligent conduct, where the landlord has acted unreasonably, or intentional conduct, where the landlord has intentionally displaced the tenant without complying with applicable laws. So those are generally the types of claims that come about from a wrongful eviction lawsuit. Are the tenant has been displaced wrongfully and it was either done negligently or intentionally. And so what are some of the damages that a tenant in that situation may allege? Well, there's a significant amount of damage. Here are some of the potential damages that can be raised by the tenant. One is rent differential. So I, tenant, would have continued living in this unit for the next 10 years, but for the fact that the landlord has displaced me. Now, that type of a claim carries a lot more weight in a rent control or an eviction control jurisdiction, where a tenancy really is protected from eviction for the long term. And they may be able to allege that they would have continued occupying a place for an extended period of time. So basically, they allege that they would have stayed in the place at the low rent that they're paying, but for the fact that they were displaced. And now they're paying $1,000 a month more in rent in a new place. So if they can prove that over the course of the next several years, they would have continued occupying that unit, but for the landlord's improper conduct, then they may be entitled to that difference in rent as damages. That's just one measure of damages that I see pretty frequently in these types of lawsuits. Another is mental or emotional distress. That is much more difficult to quantify, but again, it is a measure of damages that is sometimes invoked by tenants in these types of situations, where they have been mentally distraught by the landlord's unreasonable or improper conduct. And if they can prove that they have, in fact, been mentally anguished, then they may be entitled to some measure of damages for that as well. Other damages may include out-of-pocket costs, such as moving costs, storage costs, maybe hotel costs if they had to stay in a hotel temporarily, or stay somewhere in a short-term rental at a high rent for a short period of time. Those types of out-of-pocket costs as well. Another is what's known as treble damages, which is really a measure of damages that is found in local rent and eviction control ordinances. That's not a state law measure of damages, but instead a local measure of damages. And depending on where the unit is, a tenant may avail themselves of those damages as well. And what that is that basically most of the provable damages that a tenant can claim and prove. Let's say they are able to establish that they've been damaged $20,000 and they get a judgment for $20,000. Well, the trebling that's authorized pursuant to some local jurisdictions automatically triples that. So instead of 20, they would get $60,000. So it's a very significant measure of damages that landlords and owners should be aware of. Also, potential punitive damages as well in some circumstances where the landlord has acted intentional or the landlord's conduct has been intentional or reprehensible. So it's in significant or severe cases, there may be some punitive damages as well that are imposed by the court. Also, costs of the lawsuit. If the tenant prevails and had to spend X number of dollars filing papers, making copies, things like that, they may be entitled to those costs as a reimbursement. Another measure is attorney's fees, and those may be imposed pursuant to the rental agreement, if there's an attorney's fee provision in that rental agreement, or pursuant to statute. And basically what that means is that if the landlord loses the case, then the landlord may have to also, in addition to all the other damages, pay for the tenant's attorney's fees. Now, typically those attorney's fee provisions are reciprocal. So if the landlord prevails, then the tenant has to pay the landlord's attorney's fees. But good luck. Usually tenants are not collectible, which really renders those attorney's fee provisions meaningless. But that's not always the case. So another measure of damages are lockout fees. So if you improperly lock your tenant out, meaning you change the lock, you force the tenant out, then there's additional potential damages of $100 per day. So those are just some of the examples of damages. And in my practice, I've seen wrongful eviction lawsuit damages exceed well over $1 million, over $1 million and $1.5 million, $1,500,000 in damages and attorney's fees. So it is not, out of the ordinary that tenants invoke these lawsuits and actually recover a significant amount of damages. And it's just something for you to be aware of. Now, what are some of the defenses to these types of lawsuits? Well, one, you've complied with the applicable local and state laws. Compliance with the laws is a sufficient defense. You acted reasonably with regard to all the steps you've taken to recover possession. Statutes of limitations. Sometimes if a tenant delays in bringing an action, the applicable statute of limitation may run. For instance, for violation of a local rent ordinance, the statute of limitations is pretty short. It may not sound that short, but 1 year. In terms of statutory limits, that's a fairly short time period. So a tenant would only have a year to bring that action, or else they may lose some rights to assert claims under violation of local ordinances. There are other applicable statutes of limitations that are much longer that the tenant could still utilize. For instance, if it's a breach of a written rental agreement claim, then that's a 4-year statute of limitations. So, and that's usually pretty much on the outside length of time for a lawsuit, which is 4 years. Anything beyond 4 years is probably going to be pretty much time barred. There's another potential defense, these types of claims. It's called the anti-SLAPP legislation that provides a remedy when a tenant sues a landlord over bringing an eviction lawsuit against a tenant. There may be some provisions in the law that allow the court to strike that lawsuit altogether, because in short, no one can bring a lawsuit against someone for asserting their right to file a lawsuit on their own, or for asserting public rights of speech. So if there's a lawsuit brought against someone or a landlord in this situation for filing their own eviction lawsuit, then that may be subject to the anti-SLAPP statutes and could be stricken by the court. So that in a nutshell is the wrongful eviction lawsuits. Now I'm going to talk about breach of the warranty of habitability lawsuits. So what is breach of the warranty of habitability? Well, first of all, every residential rental agreement, whether it's in the contract or not, has an implied provision to deliver the rental unit in a condition that is fit for residential occupation, and the landlord has a continuing obligation to repair all defects which render that unit uninhabitable. So the landlord, for the entirety of the tenancy, has an obligation to make sure and ensure that the unit that is being rented to the tenant is habitable. In short, it must substantially comply with all state and local building and safety and housing codes. If it doesn't, then it may be in violation of the warranty of habitability. Now, many of the examples of what would render a unit uninhabitable are pretty much self-explanatory and would be common sense, really. But there are some that you may not be quite aware of. But generally, effective weatherproofing, unbroken windows, working plumbing, heat, and things like that. One thing that I wanted to highlight is that the unit needs to be free from rodents and vermin. The reason I point this out is because I see bed bugs a lot that come to my attention. I see a lot of lawsuits and claims by tenants about bed bugs. So even if there is a bed bug outbreak, the landlord should act quickly and reasonably to address that situation and ensure that the bed bugs are eradicated. And one other issue that I see is another habitability that's specifically per code is that the landlord must provide a locking mailbox for most rental units. So you may not be aware of that, but you need to provide some form of a safe mailbox receptacle. And some local laws impose additional habitability requirements and provide additional avenues for tenants to bring claims against landlords for violating those and potentially harassing the tenant. Now, one thing I want to point out is that there are some what are known as toxic substance claims that are commonly or occasionally brought by tenants that can fall within the breach of the warranty of habitability type lawsuit. And those, the big three that I have seen in my practice throughout the years, sort of in the order that I've seen them, it seems that these sort of evolve over time. And years ago, the common popular one was asbestos claims, exposure to asbestos. And then I've seen that evolve into lead-based paint or lead exposure type lawsuits. And now the sort of the toxic claim du jour of the day is mold. I see a lot of mold cases. Now I do still see some asbestos claims and lead-based paint claims, but mold seems to be the most common claim. And so just for instance, a couple things with regard to some of these toxic claims are, one, for asbestos, there is a presumption in all rental units when there's any materials that were installed in that rental unit prior to 1981, there's a presumption that there is asbestos-containing materials. Similarly, for lead-based paint, any housing that was built prior to 1978, there's a presumption that there's lead-based paint in that property. Mold, really mold is everywhere. There's mold in the room I'm sitting in. There's mold in the room you're sitting in. It's just really elevated levels of mold are when problems are created. So when there's excessive moisture and there's excessive mold, whether it's airborne or on the surface. So those are some of the more common types of breach of the warranty of habitability claims that I've seen. So now the habitability lawsuit, well, that's a lawsuit that's filed by a tenant alleging inadequate conditions. And it can be based on several theories. One, breach of the rental agreement. It can be based on violation of applicable state and local laws. It can be based on a landlord or owner's negligent conduct or intentional conduct. And really, it is the tenant's burden of proof to establish that claim. A tenant must first prove that the condition exists, so that the uninhabitable condition exists. Second, that the landlord knew or should have known of the condition. And third, that the tenant has been damaged. That's really it. That's all the tenant has to allege. And that's really why I see so many of these types of lawsuits. It's very easy to allege. And then it puts the landlord on defense. But again, it is the tenant's burden to prove that. Now, what are some of the damages for these types of claims? Well, one is rent abatement and possibly retroactive rent abatement. Let's say January 1st, there was a mold outbreak and the landlord was aware of that and didn't do anything about it until March 1st. Well, the court could come in and reduce the tenant's rent from January 1st all the way to March 1st. And let's say they put a value of 50% of the rent on that reduction. And then any rent that was paid, if the tenant paid the full rent for those 2 months, well, the landlord may have to reimburse the tenant 50% of that rent for those 2 months. That's an example of a retroactive rent abatement. The court could also reduce the rent permanently or indefinitely until the condition is abated. So if it is an ongoing condition, the court could say, your rent is reduced by 50% until that condition is abated. And then if that takes another 6 months for the landlord to clear it up, then that could be for the next 6 months, the tenant is paying half the rent, for instance. And like with a wrongful eviction lawsuit, the tenant could claim mental or emotional distress and get some measure of damages for that. The court can also issue an order to repair, so it can tell the landlord or the owner to repair the defect, and if the landlord or owner doesn't, then the court could hold the owner in contempt. and there could be further measure of damages, and maybe even possibly taking control of the property. Again, there can be a measure of treble damages, which is that tripling measure that I mentioned earlier that could be imposed or invoked under some local rent eviction control ordinances and jurisdictions. Punitive damages as well for conduct that is intentional and reprehensible by the landlord. And again, attorney's fees and costs can be invoked as well. So what are some of the defenses to this type of a lawsuit? Well, the tenant caused the defect. Generally, the landlord cannot be held liable to the tenant if the tenant was the one responsible for creating the uninhabitable condition. In fact, the law, and most rental agreements also include these provisions, but there's a state law that requires a tenant to, one, keep the unit in a clean and sanitary condition, two, properly dispose of all trash and rubbish, three, properly operate all appliances and fixtures, and not to destroy or deface the property. If the tenant is improperly doing any of those things, then the tenant is responsible for the damages that arise as a result of that. So there are some landlord protections in the event where the tenant is the one who's responsible for causing the damages. Another possible defense is the landlord was unaware of the condition. So the tenant simply sues the landlord was unaware of it, and as soon as the landlord becomes unaware of it, the landlord quickly addresses it. So that's another potential way to defend that type of a lawsuit. Another one is that the landlord acted reasonably. Maybe the damage was so prevalent that it took 30 days or 60 days to get a contractor in to actually repair the damages, which under the circumstances may have been reasonable. So once the landlord is aware of the defect, the landlord then immediately undertakes to repair it and does so within a reasonable time. That is another potential defense, that type of a lawsuit. Now, it's not very often that you hear about state or local laws passing laws that protect landlords. These days, the vast majority of laws are tenant protection laws. Well, in 2016, there was a law fairly recently that was just passed that gave landlords some guidance in mold claims and some protection. Per these laws that were just passed a couple years ago, a landlord is not responsible for damage resulting from mold when, one, the landlord had no prior notice of the mold, two, the mold resulted from poor housekeeping, or three, the mold is minor and found on surfaces where moisture typically accumulates. Showers, bathrooms, maybe even sometimes around the kitchen sink. So those types of mold, there are some potential protections for landlords against claims by tenants in those circumstances. Also, lead-based paint, that you may have some defense or some assurance or limited liability if you have hired a lead-certified painting contractor to address any potential defects that may have caused some lead-based paint. Again, statutes of limitations. There are various statutes of limitations that may protect you as well. Now, what is a practical course of action? I'm going to wrap it up here. I've talked about just a couple of types of lawsuits that I see in my practice quite regularly: wrongful eviction and breach of the warranty of habitability. What are some things that you can do to try to minimize your liability? Well, one is at the rental agreement stage, include all applicable disclosures. That includes asbestos disclosure. Remember, if your property is built before a certain date, that was 1980 or 81, I believe it was, you should include with your rental agreement a disclosure that there very well could be asbestos. And certainly if you know there's asbestos, then you should disclose that. Two, lead-based paint. Again, for properties built prior to 1978, there's a presumption there's lead-based paint, so you just should disclose that to your tenant with a written disclosure. And also, there's a lead-based paint booklet that should be handed out as well at the commencement of every tenancy. Again, just informing the tenant of these potential risks for property built prior to a certain date. Similarly, there are mold disclosures that you can include, informing the tenant of how to deal with mold and making sure that they properly ventilate and wipe down all moist surfaces. And bed bugs, there's a new disclosure that was required as of 2017 that requires all landlords to disclose certain information about bed bugs and what tenants should be aware of when there is a potential bed bug outbreak. So those are just a few things that you can do at the outset of the tenancy to help protect you. Also, in part of the rental agreement, make it a requirement that the tenant notify you in writing of any defects or any issues. Now, that doesn't mean ignore oral complaints, but just try and get into the practice of encouraging the tenant to submit all complaints in writing. So then that way you document the complaints. And then also respond to tenant complaints and concerns promptly and reasonably. Make all needed repairs. Document what you've done in writing. Document your interactions with the tenant. Again, not only is this creating a paper trail, but in the event that there ever is litigation, we can then go back and show the paper trail to document everything that you've done. Because conveniently, tenants misrepresent things that are done orally, or they change stories to benefit their potential claims. So try to document everything that you possibly can in writing. Don't ever retaliate against the tenant for invoking their rights or making complaints, and don't discriminate. Know the laws of your particular state, and always give proper notice to terminate when you do have to terminate a tenancy. And one other potential way to mitigate your potential liability is insurance. As a landlord, you should have insurance in place that protects you as a landlord, and that should be for minimum liability. Like I said, I've seen claims that have been successful by tenants in excess of $1 million. So remember that and think about that when you are getting your insurance, and make sure that you get a policy that does cover you as a landlord. And specifically, I'm looking for items or coverage that protects you for wrongful eviction and personal injury type claims. And then if a lawsuit is filed against you or against the property owner, the owner or landlord should promptly give that lawsuit to the insurance company. So hopefully you've got the insurance company in place to help protect you. And in that situation, you give it to the insurance company, and hopefully they pick that up and help defend the lawsuit. Don't miss any responsive deadlines waiting for an insurance response. Always make sure that you comply with any deadlines in that particular lawsuit, and just consult with an attorney to make sure that you are properly responding and have properly tendered that lawsuit to the insurance company. So hope you found this information helpful, and I'm happy now to turn this over to Harry Barth, who's going to give you some very helpful, informative information about how to utilize and avail asset protection strategies and hopefully further minimize your potential liability. Thank you very much.
Well, good afternoon, everybody. Good morning or good evening, whenever you're listening to this. I am Harry Barth. I'm the managing member and senior partner of BarthCalderon, LLP. And I'm glad to be with everyone to talk a little bit about asset protection planning. So I guess there's as we talk about asset protection planning, you need to understand what it really is. What it really is organizing one's assets in such a way that it allows us to level the playing field in the event a predatory or an overly zealous plaintiff is coming after us, and everything that we've worked our entire life for is subject to claims and jeopardy. Now, before I get going in depth a little bit today, I guess there are 3 rules or axioms that we should understand. I think it's really important to understand axiom number 1, and that is asset protection planning, ladies and gentlemen, should not be engaged in after an event occurs. Now, you may find that to be silly to think about it, because we wouldn't call the fire insurance people and say, our house is burning and we have inadequate coverage, can you increase the coverage? Or we wouldn't call the people that have insured our automobiles and say, okay, well, we just had a terrible accident on the freeway and we're not so sure we have enough liability coverage, could you please increase our coverage? But believe it or not, we do get calls from people who've listened to our material, heard our seminars, or are familiar with our firm, saying, this event has occurred on prior, and what can you do to help me? Well, please understand there are things that we can do to help everybody, but they're not as effective as they are when asset protection planning is engaged in at the appropriate time, and that's when there are no storm clouds, no problems, and no prior events. So that's very important. Call it axiom or rule number one. Axiom or rule number two is, and this is kind of an urban myth, I don't really know where it comes from, but living revocable trust, the trust that we put together for estate planning purposes. They're very important documents to help avoid probate, to make sure that children do not, lose their inheritances to drug dealers. They're very important, to put together a game plan for family distribution in the event of death. And one other thing that is very important to understand is that living revocable trusts do not provide any asset protection whatsoever. I think it's important for you to understand that. It's an urban myth. If you can reach the assets, a creditor can reach the assets. The third axiom of asset protection planning is that I have insurance for that. Don't get me wrong. Insurance, or proper liability insurance, is a very important component of asset protection planning, and we look at that insurance all the time for gaps and adequate coverage. But insurance is not the know-all, end-all of asset protection planning. I don't know why this is, but we seem to believe or have this concept in our minds that the amount of liability insurance that we have is the maximum amount that we'd be subject to in a claim. So clients of ours proudly will say, we have $2 million or $3 million worth of liability insurance. And what they're really saying is that we don't believe that we will ever have a judgment that's greater than the value of the insurance that we have. Well, that's a real misnomer. We had a client of ours had $10 million worth of liability insurance and did receive a $22 million judgment for wrongful death in a work-related environment. So I think it's important to understand that we can always have a judgment or create a liability that's greater than the amount of coverage that we have. The other problem that we face is an over-reliance on insurance. If the insurance policies were as simple as we think them to be, it'd be one page long. It says, this event happens, we pay. However, insurance policies are 65 pages long with all of the covenants, conditions, and exclusions that make up an insurance policy. So if we are within the 9 dots of the coverage, the insurance carrier may be able to take over some of that risk from us. But if we're outside those 9 dots of coverage, we may not have any coverage at all. Examples of that could be exemplary damages, special damages, punitive damages, and for those of us that own property, sometimes use of the property for not a specific purpose. I give you an example of use of property not for a specific purpose. One of our clients was a physician who owned a building, and on top of that building, they had a repeater at that time for the old AirTouch cellular. And about 10 or 12 women over a 5-year period of time claimed that they had miscarriages while working in that building as a result of the interference of the microwave radio waves. And they sued. And it was to our dismay, or our client's dismay, that having a microwave repeater tower on a building was not related to the use of the building, and coverage was denied. So we want to make sure that we have adequate insurance, appropriate insurance, but the over-reliance upon insurance is not appropriate. Let me bring that home a little bit further. If we went to our accountant and our accountant says, well, look, these corporations that we have, these LLCs that we have, they're all too complicated. They require books, records, and minutes. We have to pay fees to the state of California or whatever other state that we are living in. And we have to file tax returns and we have to open bank accounts. Why don't we just turn around and disband all of those protective entities and just buy a large umbrella insurance policy to cover us? I think that would be a gross mistake. Of course, the insurance policy could be canceled on January 1st of the following year at the insurer's whim. So insurance is important, but it's not the know-all and end-all. Well, let's take a look at some of the statistics that are really interesting. And that is 95% of all litigation in the world occurs here in the United States of America. Only 5% occurs out of the United States of America. And I've always said, and I will continue to say, that our legal system, I believe, is broken. Yet, at the same time, it's the most sophisticated legal system in the world. And the result of that, I think, is a relatively dangerous situation. In addition, last year, best guess, approximately 50 million lawsuits were filed in the United States of America. Now, yeah, we have to understand that every divorce is a legal action, a lawsuit, and every criminal action, environmental action, tax action, immigration action, contract action, tort action, pretty much every interrelationship with the judicial system begins with a lawsuit. And then lawsuits and their attendant costs represent, my God, close to 2.7% of our gross domestic product. So it's a big industry in the United States of America, and I don't expect that it will change very soon. An example of the system being broken is that I believe that over the years that the utilization, for example, of punitive damages, which was once meant to be wanton, willful, and reckless conduct, has really changed to now being 12 people in a jury box trying to legislate behavior. We've seen that with the way McDonald's brews coffee. We've seen that with the Aaron Andrews Awards and the Hulk Hogan Awards, where juries awarded large amounts of punitive damages in order to get us to change behavior. There's a lot I could talk about that. I don't mean to be political, but I think it's very important to understand that activist judges and activist juries are not the friends of people that have assets. Now, I'd like to kind of put that in terms that could be a little bit more tangible. So, if an individual had too much to drink, and this individual had virtually no assets and virtually no insurance, and that individual runs into you on a freeway, severely injuring yourself and or your family, you're not going to sue. There's nothing to get. The best you'll get is the uninsured motorist coverage that you may have as part of your automobile policy. You now change that picture that the person that perhaps had too much to drink or was careless and or negligent ran into you and injured yourself and your family. If that person had significant assets, real estate, apartment buildings, home, savings accounts, brokerage accounts, there's no doubt that we'd bring a legal action against that person and sue them for full recovery as much as we possibly can. Asset protection is designed in such a way as to have it, although you have assets, to not generally make them available to creditors and to allow the creditors to take the insurance that we have, making sure we have adequate insurance, and leaving our personal assets alone. Asset protection itself, we'll talk about the specifics in a moment, is not a new concept. Back in the Middle Ages or in the late Middle Ages, as a result of many, many wars, families and kingdoms having won that war were entitled to the spoils of war. And if they had taken the spoils of war that they fought for the last 20 years to win, losing lives, limbs, and investing a lot of money in that, and brought back the spoils of the treasures back to their little idyllic village that may look like Hobbit land, with round doors and thatched roofs and blue skies and cumulus clouds in the sky that look like marshmallows. And we laid everything that we worked so hard for down in the center of the square, which we will now call this not Hobbitland, but Naiveville. And the barbarians and others and thieves that lived in the woods would come out and steal everything that we worked our life for. So even back then, they engaged in asset protection planning. They built a castle, and the walls were thick, and they were designed to protect the assets that were kept behind those walls. But it wasn't enough just to have the walls. They dug a moat, and in that moat, they filled it up with water to make it more difficult for people to pass over it. Allegedly, it was filled with crocodiles and alligators and pit vipers. How they got them back in merry old England, I have no idea. And there were archers and turrets, so there were layers of protection. And the hope was that the people that were coming to take their assets away would reach the fortress that had the least fortifications and the least protected, and they would pass by the ones that were well protected. Well, today, for those of us that operate law firms, it's not very much different. If your assets are well protected, and we discover that, the odds are we will settle with you for the amount of your insurance, or maybe a small percentage above that. And for those of you that are not well protected, we will bring legal actions to recover. Now, lawsuits, as you all know, are not just about money. They have an emotional toll, there's a stress toll, there's a family toll as a result of a lawsuit. And so it's best to try to avoid them, settle them with appropriately and quickly, perhaps with a mediation, which can be done when we have an appropriate asset protection plan in place. Now, let's talk a little bit about some specifics. I think it's also important to understand that many of the rules that we learn about in asset protection are state specific. So today I'm going to be talking pretty much about California rules, but for those of you in different states, the rules may be slightly different, and we'll be more than happy to help you answer any questions that you have about other states other than California. So God forbid, we drop the cell phone and we go to pick it up and while driving the car, and we didn't see the stop sign as a result of it, and we crashed the car and severely injured a number of people. The contingency fee lawyer is going to come, and they're going to collect 1/3 of their recovery and sue us pretty much for everything we're worth. Now, I'm not going to spend time today going through the countless cases over the last 40 years and thousands of clients that we have to run through everything. We all understand we could change a lane improperly on a Saturday night, not see the motorcycle, and cause severe injuries that the amount of damage is almost practically unlimited. And so now what I want to do a little bit is talk a little bit about what happens. So many of you are owners of real property and commercial properties and rental properties. So I want to talk about those a little bit and see if we can throw some light. We all recognize pretty much that in the absence of planning that our stocks and bonds or cash are gone. We recognize that many of our assets will be taken from us to cover any judgment that's in excess of the insurance. A lot of people don't even recognize in California what the homestead exemption is. So let me just share it with you that if one person is occupying the property or title, $75,000 of equity is exempt from the claims of creditors. If we have 2 or more people occupying the property, $100,000 of equity is exempt from the claims of creditors. And if we have a disabled person or someone over age 65, $175,000 of equity is exempt from the claims of creditors. If we have more equity than that, our home will be taken, it will be sold in a forced sale, and you would get a check for the homestead amount. It's amazing as I go around the state of California and I speak and teach this subject matter, and I ask the audience about what they feel the homestead exemption is, or if they would lose their home. About half or 50% or 60% of the people owning nice sized properties in California believe that their home is homesteaded and they wouldn't lose their home in a situation like that. That is not true. The other thing too is that when we look at a real property, we see people that'll have rental property that's just held in their own name, or joint tenancies, or community property with rights of survivorship, or titled in a living irrevocable trust. And what I want to do is take a few minutes and talk about the various liabilities that are associated with that. I think there's two kinds of liability. One's called outside in and inside out liability. Now, outside in liability is a liability that's coming to the owner of the property from an event unrelated to the property. So on Saturday night, I crash my car, severely injure people, and a judgment comes against Harry, and I'm going to be able to look at all the assets that Harry has. If one of the assets that Harry has is a apartment building or commercial property that has net equity of $1.5 million, they will just take that property, put a lien against it, foreclose on that lien, and use that $1.5 million to satisfy the claim. That's an outside-in liability. And a lot of properties and a lot of businesses, too, are lost as a result of an owner of the property having a liability rather than a liability rising up from the property. An inside-out liability is a liability that causes a landlord-tenant liability, slip, fall, mold, and the list goes on and on and on, failure of a carbon monoxide detector, failure of a window to open properly. So there, the situation is that the plaintiffs will sue the landlord. Now, what the landlord is community property, husband and wife, joint tenants, trust. We have unlimited liability to the full extent of our net worth. So even though the property may be worth $1 million or $600,000 of net equity, our entire net worth, our homes, our savings accounts, our businesses are all subject to that claim. So that's what we call inside out liability. So let's talk a little bit about some of the things we should or should not do. So one of the things that we see is that, or most of you should understand, is that you should really not be a sole proprietor when you're in any business of rental real estate. I pretty much say that universally. So we should have a limited liability entity that's in place that will help us protect ourselves. So let's talk about that. So if we have an inside-out liability, if that property has $600,000 of equity, that should be it. In other words, if I don't care if there's a judgment of $2.5 million against the landlord, if the landlord is that LLC, the liability would be limited to the value of the assets that are inside that LLC. Of course, there's some exceptions if you don't operate it properly or don't treat it as a business, but assuming that it's run properly and it's set up properly and structured properly, that limited liability company will limit your liability to the value of the asset that's inside of it. Of course, that also gives us an opportunity to perhaps lower the amount of equity that's inside that box and thereby reduce the exposure that we have to the tenants at the same time. So people will ask me, and I think that that's significant. I mean, it's really, really significant. I mean, an unlimited liability in a very, very difficult and highly dangerous area, being a landlord, versus limited liability. I don't even think that there is a question of whether or not that property should be encapsulated within that entity. The other thing too that I think is very important is that we understand. People ask me, well, how many properties can I place inside an LLC? And I guess that's strictly a business decision. So think about it. If we have 3 properties, each one with $1 million worth of equity that sits inside the LLC, we have now the landlord with a net worth of $3 million. And now, not only do we have a consolidation of the equity, we also have the number of targets to that equity is increased exponentially in the fact that all of the tenants in all three properties, all of their guests and all of their invitees, all are potential plaintiffs against the landlord. So we've increased the number of targets against a large block of equity. To me, that seems to make no sense. From an asset protection perspective, yes, it costs a bit of money to set up an individual limited liability company. Yes, it costs a bit of money to maintain an individual limited liability company, but I think that we should have almost as many limited liability companies as we have properties, or package them functionally to make sure that we don't have too much equity in any one box. It's just simple math and simple and basic asset protection planning. When done properly, we should have no problem with a Prop 13 reassessment. When done properly, we should have no problem with any lenders on those LLCs. And then, of course, those LLCs could then be placed inside our living revocable trust for the purpose of probate avoidance and privacy. Now, the other side to that is the outside-in liability. As I told you earlier, that if I have a liability to the owner of the property, the creditor is just going to take away the property. When the limited liability company is structured properly, that will not be a remedy that's available to the plaintiff. The best that they should be able to do is basically place a lien over the distributions that come out of that LLC, but they will not gain any managerial control. They will not be able to reach inside and take those properties away, and they won't even be able to force a distribution. So now there is a secondary remedy under California law. If it's a California limited liability company called foreclosure, we don't see it very frequently because it has adverse tax consequences to the creditor, and usually the areas are able to be resolved. And even in a foreclosure, still the creditor is not going to be able to receive the revenue nor have any managerial control. So I think it's really important that we have real property, or assets similar to that they be structured and held properly to protect ourselves. I think it's absolutely critical. What we've seen on several occasions is we see properties that are held by corporations, more specifically S corporations. That is an error as far as I'm concerned, for a couple of reasons. One, from an internal liability perspective, we need to make sure that we now keep appropriate books, records, minutes, shareholder meetings, board of director meetings. Those are not voluntary. Those are mandated by the state. They need to be done. Also, I think it's really important to understand that if I have a liability to the owner of that corporation, that I would be able to take the stock. And if I take the stock, I would be able to liquidate the entity and grab the building. And it just does not work properly from an outside-in liability perspective. And there's more homework to do on an inside-out perspective. And also from a tax perspective, having property owned by a corporation is usually not the most efficient, and actually could be quite detrimental in the way its property is held. So if you have properties that are held in your own name, trust name, living revocable trust name, I think it's really important that they be encapsulated appropriately and properly in an appropriate entity. I also think it's very important that if we have property that is already encapsulated in a corporation, that we take a look at the best ways to protect that as much as possible by protecting the shares of stock in the corporation. We're not going to be able to do much to change the tax status, but there are a lot of things that we can do. But that's really a bit of a problem. Please don't make that error. All right. So now, just as we move along a little bit, as far as asset protection is concerned, we just did an expanse of various different methodologies for protecting real property. And one of the things that I think it's also important to understand is that when we are looking at these various different properties and the way in which they're held, that we do have a great opportunity to have our choices, put together the various different bells and whistles to make sure that we take a valuable asset and protect it properly. There's a lot of controversy that runs around as to whether or not the limited liability company that we use should be a California limited liability company or Nevada, Delaware, Texas, Montana, South Dakota, LLC. And the controversy runs first around a tax issue. Let me just emphatically state that if the property is in California or is even managed out of California, that whether it's a Nevada limited liability company or Wyoming limited liability company, for example, they need to be foreign filed and registered in California, and we do need to pay all tax associated with that in California. So it's not a tax savings. Where the next question comes about is whether or not it's worth the extra $300 or $400 a year to use an out-of-state LLC over in-state property. Well, I always think it's better to adopt the best law that we possibly can find. And I think that there are laws that, or LLC laws that do not allow that secondary foreclosure remedy. The particular states that I mentioned do not, versus California that does. At least it creates an argument as to whose law should apply. And I think every time you create an argument for those people that are representing you, it has settlement value and can be very, very helpful to you. Let me quickly run through a few other things. Irrevocable trusts, trusts that are created by others for us, are successful asset protection tools for holding real property and other types of assets. When we create them for ourselves, an irrevocable trust or an asset protection trust, they've gained so much more favor and seem to be adopted more and more, depending on the state that you live in, and is something that should be considered under certain circumstances. The appropriate and proper utilization of retirement accounts, 529 plans, and tangible assets are very important that they be organized in an appropriate and proper way. Remember that the main goal of asset protection planning is not to pay for something that we have rightfully incurred the liability for, but to level the playing field, allow it to be settled within a reasonable amount of time for a reasonable amount of money, so a tragedy does not have to become a greater tragedy than it already is. So with that, my admonishment to all of you is as follows. This was a short period of time that I was able to spend with you. I think it's very, very important that everyone should take a look and have an evaluation of what their exposures are and their insurance coverages are, and see what opportunities and tools are available to you to help you best protect your assets from the claims of third-party creditors. After all, you've worked all your life for them, you've sacrificed for them, you've built those assets, and I think it's really critical that we protect them. So thank you all very, very much for the time, and I hope you found that the information is useful. We probably will have more in this series in the future. Thank you very much and have a great day. Bye-bye.